Hello, and welcome to Schiff Hardin's presentation, Curbing Employee Speech and Activities. You're entitled to your own opinion, but we are pleased that you have decided to join us for this important topic. A copy of the presentation can be found in the handout section located on the left-hand side of your screen. Questions can be submitted at any time by using the chat feature in the lower left-hand corner of your screen. If time allows, our speakers will answer the questions at the conclusion of today's presentation. If we run out of time, the speakers will follow up by email to answer your questions. I would now like to introduce today's speakers, Patricia Slovak and Matthew Callahan. Patricia, the floor is now yours.
Thank you so much, and welcome to everyone. Thank you for joining us for this discussion of how employers can and or should deal with problematic speech and activities by their employees. My colleague Matt Callahan and I will be discussing the parameters for controlling employee activity both inside and outside the workplace, and will suggest some policies that may be useful to employers. Then we will explore some hypotheticals and hopefully leave some time for questions at the end. Let's start with a discussion about speech and behavior in the workplace. At the outset, let's be clear that we are not talking about the First Amendment here. It is largely not applicable in the private employment sector. Employers in the public sector do have to be concerned with the First Amendment, and by way of commercial, Schiff has extensive experience dealing with First Amendment retaliation claims against public employers who terminate employees. However, our focus today is on those forms of communication by employees which are protected from discipline, even by private employers. Much of the law regulating employee speech remains unclear, and in part this is because many of these provisions, particularly the state statutes, are not frequently litigated and have generated little case law. That is changing, however. Social media has greatly increased the visibility of employee speech, both at work and outside of work. And employers are increasingly making decisions based on this additional information. Plaintiffs' lawyers have accordingly begun testing the limits of these laws, and this trend shows no sign of slowing down. Because of this new world, it is important to understand what employee conduct an employer may control and what it may not. There are some activities which may clearly be controlled by an employer. So, for example, employers may have policies which prohibit violations of the law in the workplace, such as sexual or racial harassment, or the disclosure of confidential medical information about other employees. Because the employer may be held liable for these actions by employees, there really is no question that an employer has the right and arguably the obligation to prohibit such conduct. Similarly, an employer has an obligation under OSHA and various state laws to provide a safe workplace. Hence, an employer may prohibit speech or activity by employees which endangers the safety of others, such as blocking exits or sabotaging machinery. This is true even if employees take such action as a protest of working conditions, because employees may have the right to protest, but they do not have the right to endanger others. Thirdly, on the list of activities an employer may prohibit, the employer has the right to prohibit speech or activities which violate the employer's lawful policies. So, for example, if the employer has a policy about protecting its trade secrets or confidential information, it may have such a policy and enforce such a policy. Although any such policy needs to be carefully vetted, since an overbroad confidentiality provision may be unenforceable as against public policy, or even worse, could expose an employer to liability under statutes such as the National Labor Relations Act if it is found to restrict the employee's ability to use information to communicate with coworkers about terms and conditions of employment. Finally, on the list of what clearly can be controlled, an employer is entitled to enforce solicitation and distribution policies so long as those policies comply with the parameters of the National Labor Relations Act. That means the employer may prohibit distribution of materials during working time in working areas and may prohibit solicitation during working time, so long as it applies the policy in a non-discriminatory way. This means, for example, that the rule can't be enforced against solicitation for union activities if it has not been enforced against solicitation for charitable causes or employee social or fundraising activities. There are certain activities in the workplace to which an employer's right to control is less clear. So if an employer seeks to prohibit employees from expressing political opinions in the workplace, it will need to tread carefully. If employees are customer-facing, or if they interact with patients, or if they deal with the public wearing uniforms which identify the employer, an employer may be able to prohibit buttons, T-shirts, hats, and the like, which express political points of view. The safest way to do so, frankly, is to prohibit all such displays in the workplace so that you do not step into the morass of trying to regulate the content of the political expression. Be wary, though, of prohibiting buttons related to union organizing activity, because the NLRB has fairly strict guidelines on when such prohibitions will be upheld. Most employers presume that they can prohibit their employees from making disparaging comments about the employer, but that is not necessarily the case. The NLRB takes the position that employees have the right to discuss their terms and conditions of employment, and that this right can extend to public criticism of such terms and conditions if it is done in concert with other employees for the purpose of raising issues about the workplace. So, is an employee protected if she critiques the lighting or air quality in the workplace in a public way? Probably yes. What if she criticizes the supervisor's haircut? Probably no. Employees' use of social media to raise issues unrelated to the terms and conditions of their employment has, as we all know, become quite a hot topic and falls into this category of less clear in terms of the employer's ability to control. If an action is taken under the guise of the employee's status as an employee, so for example, the ESPN anchor who was suspended for criticizing the president's actions, or the attorney at CBS who has been terminated for a comment about gun control in the wake of the Las Vegas shootings, the employee's actions may not be protected, especially if the actions violate the employer's lawful policy governing the use of social media. We will talk about such policies a little bit later. Finally, political or social protest in which the employee is clearly identified with the employer. So, for example, sports figures kneeling during the national anthem to protest police violence against African Americans, or employees taking action in support of Fight for 15's campaign to obtain higher minimum wages. Both of those sorts of activities are in the gray area. For example, the football players, at least some of them, have filed unfair labor practice charges against the team owners who have threatened to fire players for refusing to stand for the national anthem. And in a case involving buttons which were worn by In-N-Out Burger employees, the NLRB found that prohibiting the wearing of those buttons in support of the campaign was an unfair labor practice. That case is on appeal to the Fifth Circuit, so it's not clear at all how either one of those sorts of activities will play out, but we will certainly keep you posted on our blog page and on our communications. On the flip side of the topic of what the employer can control in terms of activities in the workspace, there are certain areas in which the law seems fairly settled that the employer cannot control certain activity. As noted earlier, discussions among employees related to the terms and conditions of their employment will be protected under Section 7 of the National Labor Relations Act. I don't think that's going to change, despite the fact that there is now a Republican majority on the NLRB. I do think that the expansion of that protection will likely stop. Union organizing activity, which takes place in non-working areas during non-working time, is protected now, and I believe it will continue to be so. And I also believe there'll be no change in the protection of whistleblowing employees and the protection against retaliation for raising complaints against employers for alleged violations of the law. So none of those activities can be restricted by employers, and I don't think that's going to change in the near future. Similarly, though, on this spectrum of consideration, there are activities which are less clear as to whether or not they can or cannot be controlled. I would say the area of speech or activity related to religious observance or safety fits this less clear category. For example, requests for religious observance, such as time for prayer or time off for Sabbath observance, should probably be honored unless the employer can show that doing so is an undue hardship. Similarly, charitable or religious solicitation, if it's conducted within the parameters of the employer's otherwise lawful solicitation policy, so for example, tables in the break room during break time, should probably be allowed, since regulation of such activity based on content alone leads to a slippery slope. Refusal to perform work that's deemed objectionable is more difficult on this analysis. If the refusal is based on safety concerns, then it should be addressed in that manner. That is, the employer should acknowledge and review it as it would any safety complaint. But if the refusal is based on political or religious or moral objections, the employer is generally free to insist that the work be performed. And last but not least on this scale is the question of what to do about the employee who distributes criticism of the employer's policies internally. So the most public example of that in recent weeks and months has been the Google Screed, in which the employee criticized Google's diversity initiative and was terminated for distributing that memo. If the distribution was internally only, and in this case it does not appear to have been solely internal, but if it were, and if it arguably related to the terms and conditions of employment, arguably it is protected communication. And my guess is that that is what the Google employee is arguing in the unfair labor practice charge he has filed. But if, on the other hand, the content of the communication, internal or not, violates the employer's lawful policy or otherwise violates the law, the communication likely is not protected. We will have to wait and see how that case plays out, but it certainly is one that has captured all of our attention. So Matt, why don't you take us and let us know what happens when the offensive speech or activity occurs outside the workplace.
Thanks, Pat. So I'd like to start by considering what activities the employer can regulate outside the workplace. And the first consideration in that analysis is what counts as a workplace. If the employee works from home or otherwise remotely all the time, then the remote location would seem to be the workplace for all purposes. And that conclusion is probably the same even if the remote work is intermittent in nature and the employee is sometimes in an actual physical workspace. The second consideration is whether the communication at issue comes after the workday is over. If the communication is made on an employer-issued device and the employer has a policy governing the use of that device, then the communication is likely subject to control by the employer. If the communication is made on the employee's personal device, the result is not as clear, and will depend more on the extent to which the communication clearly identifies the employee as an employee of the employer. The analysis also changes if the activity or communication occurs at an employer-sponsored social event. The employer should assume it is liable for behavior at such events, particularly when attendance is mandatory, and should have a policy in place expressing its views as to what is expected at such an event. Then action can be taken against an employee who violates the policy with little concern. If no such policy exists, or if the activity occurs at an event which employees attend but which is not sponsored by the employer, taking action against an employee for offensive behavior may be more difficult. Finally, if employees travel for work, then the behavior in which they engage during that travel can be assumed to be occurring in the workplace for purposes of employer monitoring and/or the controlling of the behavior by the employer. Now that we've established where the workplace is and where it isn't, we can turn to the question of what activity an employer may control that occurs outside the workplace. Some such activity seems clearly to be subject to control. For example, an employer may stop an employee from working for a competitor while still employed for the employer, or may stop an employee from disclosing trade secrets even if the disclosure happens outside of work. Generally, criminal activity, even if it's not work-related, can be controlled if it is also a breach of trust or fiduciary duty or causes negative publicity for the employer. The concept of employee disloyalty is a bit murkier, but there is some case support for the idea that an employer may take action against employees who exhibit disloyalty to their employers in some public way. For example, in the Micklin Enterprises case that's listed on the slide there, the en-banc Eighth Circuit found that the employees' public statements disparaging the quality of their employer sandwich shop's food constituted such disloyalty, and found that these statements were not protected under Section 7 of the NLRA. In contrast, the D.C. Circuit, in the DirecTV case cited on the slide, found that technicians who told press during a labor dispute that DirecTV instructed them to exaggerate to potential customers the risks of using unapproved devices in order to drive sales was found to be permissible hyperbole on the part of the striking employees and did not violate the duty of loyalty. The two courts also disagreed about whether the employee's subjective motivation was properly considered in the analysis of whether their statements constituted a breach of loyalty. It's more difficult to decide whether an employer can discipline employees for actions which are lawful, non-work related, and undertaken outside of work. This issue became very evident when some employers took action against employees who participated in the recent Charlottesville white supremacist demonstrations, despite the fact that these employees did not identify their employers during the action. Similarly, employees who are active in unpopular causes have faced loss of employment. For example, the attorney who is no longer employed at his law firm after the firm learned that the attorney was a major supporter of a neo-Nazi record label. In the past, employee participation in such demonstrations or activities outside of work would usually not have come to the attention of their employers at all. However, based in large measure on the use of video and photography function on cell phones, there's been an increase in the calling out of such activities by members of the public, increasing the pressure on employers to take some action against these employees. Employers should take care in taking action against such employees, however. Some state laws bar employers from terminating or disciplining employees for certain kinds of lawful off-duty conduct. For example, North Dakota and Colorado have statutes prohibiting private employers from terminating an employee for any off-duty lawful conduct, and Connecticut has a statute that protects employees for almost all activity protected by the First Amendment, and we've listed a couple examples on the slide there. These statutes are often implicated in those states which permit off-duty use of substances which may still be controlled or even illegal under federal law, like marijuana or cigarettes. Other states, like California and South Carolina, have statutes that protect employees from employer actions that coerce or threaten them on the basis of the employee's political beliefs. In addition, if there is a question of protection of the activity under the National Labor Relations Act, it may be more difficult to discipline employees, even for behavior that would otherwise violate the employer's policies. For example, the undisputed use of racial slurs by a picketer was deemed to be protected speech by the NLRB in the Cooper Tire case, which we'll talk about in more detail later in the presentation. One other concern which an employer should deal with in determining whether to discipline employees for off-duty activity is the issue of defamation. This can arise if the information which the employer receives about the alleged activity of the employee is, in fact, not correct. For example, if an employee is misidentified in a video containing offensive behavior. If the employer wants to take such action, it should follow the same procedures it would follow in any investigation of misconduct, confirming the activity on the part of the employee through interviews and other evidence before taking any action to discipline anyone. As we generally advise our clients, employers are well served by having clear policies and practices related to employee behavior, as those policies facilitate both good performance and appropriate discipline. In the context of this discussion, there are several policies and practices employers may want to consider to make control of employee behavior more clear and enforceable. Among the policies to consider are the following: a civility policy in which the culture of the employer is articulated and the way in which employees are expected to be treated each other is set forth, an anti-bullying policy in addition to the employer's existing anti-harassment policy. Bullying is generally not unlawful under the discrimination laws, but it is certainly often cited in hostile workplace claims. An employer can minimize the escalation of bullying to unlawful harassment by controlling bullying in the first instance before it becomes a big enough problem for a lawsuit to develop. A policy on the use of social media generally, as well as a policy on the employee use of the employer's computers or other official accounts of social media. A policy on general social media use should articulate the employer's restrictions on the identification of one's employment relationship, and the policies on use of the employer's official social media account should set even stricter parameters on what may be said while the employee is representing themselves to be a representative of the employer. A lawful solicitation and distribution policy can help an employer control inappropriate activity in the workplace. And a political activity policy can limit the noise, especially during campaign season, but it does need to be carefully crafted and uniformly enforced. Employers may well decide that such a policy limiting political activity is not worth the problems it may cause, but an employer can nonetheless control excessive political dialogue through other means, such as a civility policy or anti-bullying policy. Pat, do you want to talk about some other policies or practices?
Thanks, Matt. I'm happy to do so. Matt's given us some idea about what policies you might want to have, and they are, as most employers know, really a safety net. When you've got clear policies, then the discipline that you take for violations of those policies is much easier to defend. So we do really hope that you will all take seriously the idea that you can create policies like a civility policy, which many employers have not had in place in the past, and it can be a good basis for you to take action. But in addition to policies, there are certain practices that employers may want to follow and that employees will benefit from your engaging in. The primary one probably is regular anti-harassment and bias training for all employees, regardless of whether you are in a state that requires you to do that on a regular basis or not. Certainly California is one of the states that does. Not all states do, but generally it's a good idea to have those refresher training courses for employees on a regular basis. And a second practice, which you may want to consider, especially in these times, is the creation of a credible ombud process or a facilitator program, different from a grievance procedure, but those sorts of ombuds or facilitator programs can encourage employees to raise issues, generally in a confidential way. Hopefully the issues then get raised in a timely and constructive manner. These are good because they not only let the employer know if there are issues that should be being addressed in the workplace of which they're not otherwise aware, but it also gives employees a mechanism for voicing their concerns, and that decreases tensions in the workplace, or it can, and it increases the employee's sense of fair treatment within the workplace. So let's look at some specific behaviors and potential responses to them. We're going to do that primarily through the hypotheticals that we're going to begin in just a few moments, but I want to make a few points generally on the topic before we begin that. Employers can limit their exposure to claims of discriminatory treatment of employee behavior by taking several steps, good practices generally. As a general rule, employers should be tracking performance and not behavior. It is always easier to defend a disciplinary action that is based on failure to perform according to the employer's standards than on behavior, which is something about which different people may argue. So performance, not behavior. The second one would be that employers should avoid situations in which there is disparate access to communication by employees. So, for example, don't let some groups hold meetings that are unrelated to work issues and refuse to let others hold meetings for their causes. If you're going to let employees hold meetings on company premises, that's fine, but you need to be able to be sure that you are doing that in a non-discriminatory way. Third, I'd suggest that employers make clear to employees from the outset that negative social media posting about the employer's product or services that harms the employer's business will not be considered protected activity and will be subject to discipline. There's nothing wrong with making that a clear statement on behalf of the employer, and I believe that it is a good idea for you to do so, remembering, of course, that criticism of management may not be controlled in most instances under the current view of the National Labor Relations Board. criticism of products can be controlled. Finally, I'd say if the employer expects to discipline, that is, if the employer would like to be able to discipline for public participation in unpopular causes, our suggestion is that employers should articulate the criteria on which they will make those decisions beforehand, so that they are not making them in the heat of the moment. Matt, can you start us with some hypothetical situations and see where they take us?
Sure, happy to do it. Let me just say also, I realize we apparently have the wrong set of slides uploaded right now, so we're working on fixing that. And if you want some bonus slides on leave accommodation, please download them before we change them over to the employees' workplace speech slides. But we'll get the right ones up there shortly, and my apologies.
Actually, we've already deleted those files.
Sorry, it's too late.
Too late.
but anyway,
we'll have them uploaded in
now.
just a minute.
So go ahead and download our slides once they get up there. So turning now to the hypotheticals, we're going to run through some situations talking about the ways in which small or not so small details can change the outcome in terms of what kind of liability an employer faces or what the outcome might be if a lawsuit is brought. And the first set of hypotheticals is going to discuss racist comments being made at the workplace. So this would be an employee saying something offensive or potentially illegal if in the physical workspace of the employer. And our first hypothetical involves such comments being made in the context of a strike or other labor dispute directed at replacement workers. I mentioned earlier the Cooper Tire decision, which is cited on the slide there. This was a decision that surprised a number of commentators. A striking worker yelled racist comments at an African-American replacement worker who was crossing the picket line. And the racial component of these comments had nothing to do with the fact that the target of the invective was a replacement worker. So the employer, Cooper Tire, felt justified in terminating the employee who had shouted those comments. During the lawsuit, the employee sued for reinstatement, and the employer argued during the lawsuit that it could be found liable for creating a hostile work environment if it did reinstate the employee who'd made those comments. But the National Labor Relations Board held that the striking worker's racist invective was actually protected organizing activity because it had occurred in the context of a labor dispute. And because the employee had not been properly fired for cause, the employer's concern about being liable for a hostile work environment was not a valid reason to avoid the remedy of reinstatement. Now, while this sounds like an outlier, it's actually not unique. Other extreme behavior has been upheld as protected activity under the National Labor Relations Act in the context of a strike or labor dispute. Such as, for instance, a man who grabbed his crotch and made obscene gestures at a female replacement worker, which the D.C. Circuit held was protected activity for which the employee could not be terminated in the Consolidated Communications case, which is also slided on the side. Employers facing picketing employees or labor dispute basically cannot be too careful in attempting to regulate or discipline employee speech. The next hypothetical we're going to look at is an employee who makes racist comments at the workplace and is fired not for violating company policy, but because the employer disapproves of the content of that speech. Even outside of the context of a strike, employers need to be very careful about the potential for state law liability when an employee is being disciplined for speech. Liability under some state laws turns on whether the employee was fired because of the policy violation or because the employee possessed a political opinion. And that can lead to very different outcomes for similar fact patterns. For example, the California Court of Appeal in the Nava case on the slide, interpreting California's statute which prohibits an employer from attempting to coerce or influence its employees' political activities through the threat of discharge, reversed the dismissal of an action where an employee was fired after what the employee admitted was a violation of firm policy. The employee had destroyed a pro-gay rights poster which the employer had hung in an employee break room. The employee met with the employer 1 week after he destroyed the poster and informed the employer that he did it because of his political stance against gay rights. The employer allegedly expressed disapproval of the employee's views during that meeting, and the employee was terminated immediately after the meeting. The Court of Appeal found that the employee had made out a prima facie case that he was terminated because of his beliefs about gay rights and not because of his actions in destroying the poster, and permitted the case to move forward. In contrast, the Fourth Circuit, which was interpreting a South Carolina statute protecting employees from discipline for political opinions, found that the employer properly terminated a mechanic who had a Confederate flag sticker on his toolbox. That's the Dixon case that's cited on the slide there. The employer offered the mechanic a chance to keep his job if he removed the sticker, and the employee refused. Another mechanic who also had a Confederate flag sticker on his toolbox, but removed it when he was requested to, was not terminated, which the court found relevant in finding that there was no violation of the statute here. While neither of these cases is binding precedent in their respective courts for unrelated procedural reasons, they illustrate that it is important to keep the record straight regarding the reason for an employee's termination, even if there is a violation of policy in the record. Moving on to our third hypothetical, we can imagine an employee making racist comments at the workplace who is also an executive of the company. Employers must remember that statements made by executives are often analyzed differently by courts when a plaintiff seeks to sue over a hostile work environment. For example, the New Jersey Supreme Court has held that a single utterance of an epithet can constitute a hostile work environment under New Jersey's law against discrimination. And that's the Taylor versus Metzger case, which is present on the slide. However, lower courts interpreting this decision have largely rejected the claim that a single epithet from a coworker can create a hostile work environment, for instance in the Nunes versus Simon & Schuster case. Accordingly, the potential liability for permitting statements by executives to pass without discipline could be greater for the employer than it would be for similar statements made by subordinates, and the risk-benefit of disciplining an employee or executive for speech may favor erring on the side of taking action for an executive's statements, even at the risk of liability under speech protective laws.
So I'm going to change up the hypothetical a little bit now. We're still going to discuss a hypothetical in which the basis is that the employee makes a racist comment, but this time the comment gets made on social media. As we mentioned above, earlier in this conversation, employee speech outside the workplace has drawn scrutiny and employer action recently. So one of the most common outlets for this behavior by employees outside the workplace, is their use of social media. Courts have largely rejected the notion that an employer can be directly liable for statements, such as threats or defamation, which employees make on social media, where the only thing the employer has done is provide the computer system over which the statements were made. And that's the Delfino case that is noted on this slide. But nonetheless, employers may wish to discipline employees for speech outside of work. Certainly there have been instances of that recently, and there are certainly times when an employer wants to do it, particularly if it's speech that makes other employees uncomfortable or which leads to negative publicity for an employer known to employ the speaker. So if you become aware of comments made by your employee on social media and you want to take action, there are ways to do it and ways not to do it. So the second iteration of this hypothetical would be the employee makes the racist statement on social media, but the way the employer discovers it is by deceiving the employee or gaining the information about what the employee posted in some other surreptitious way. So employers need to be careful because you can start incurring liability even before you take action to discipline the employee. For example, several courts have found that employers violated the Stored Communications Act when their managers accessed an employee's password-protected website using passwords that were provided by other non-managerial employees who were authorized users of the respective website, but not by the employee whose website it was. That's the Cant case that is noted on the slide. Another court held that a former employee who returned a company BlackBerry device, certainly that behavior is common when an employer provides the device and then requires that it be returned when the employee is terminating employment. That's what happened in this case, and she returned the BlackBerry device. She neglected to delete her Gmail account. She apparently thought she had done so, but she had not. And the court found that she was permitted to state a claim with those facts under the Stored Communications Act when a supervisor read her personal emails and disclosed some of their contents. So the Ealing case listed on the slide here elaborated a bit on the idea of privacy for the employee. There, the court held that the employee's Facebook wall posts were protected under the Stored Communications Act because those posts could be viewed only by the employee's Facebook friends, which did not, surprisingly enough, include the employer. But in the Ealing case, the court found that the employer had not violated the Stored Communications Act because one of the employee's existing Facebook friends voluntarily provided the employer with the post. That is, the employer did not take action to access the private page. Remember that the Stored Communications Act is not the only source of potential liability for non-voluntary access to an employee's social media site. An employer could also be found liable under either such common law actions as tort of intrusion upon seclusion, or, for example, the California Constitution's right to privacy, or the National Labor Relations Act. So another iteration of this hypothetical might be, what happens if the employee makes racist comments on social media and those posts cause a boycott of the employer's business? As we discussed a little bit earlier, when the employee's speech damages an employer's business directly, this sometimes constitutes a reason to discipline or terminate the employee. For example, the Supreme Court has recognized that an employee manifests a breach of loyalty toward the employer, such as by distributing flyers or disparaging the employer's TV programming. An employee who does so may be terminated. That's the Jefferson Standard case on this slide, and that really is, despite its old date, kind of the leading jurisprudence on this idea of duty of loyalty and breach of loyalty. In that case, in the Jefferson Standard case, the court found that the employees were not protected when they distributed those flyers because their behavior manifested disloyalty toward the employer. Amazingly, sometimes state laws can be helpful on this issue to employers. For example, Colorado's statute protecting employees from discipline for out-of-work speech has a provision that makes loyalty a bona fide occupational qualification and thus permits an employer to fire an employee who takes disloyal action, such as sending a letter to a newspaper publicizing an employer's decision to hire hourly contract workers. That's the Delta Airlines case that's on the slide, and the employee there was concerned about the fact that the employer was replacing full-time laid-off workers with hourly contract workers and sent a letter to the Denver Post, I believe, objecting to that behavior by the employer. The court found that it was a breach of loyalty to have done so and grounds for termination because loyalty was a BFOQ under the Colorado statute. But employers are not always free to discipline based on a breach of loyalty. For instance, that same Colorado case stated in dicta that if the employee had been publicizing safety complaints about the workplace instead of the alleged change in hiring policies which hurt current employees, the letter to the newspaper would not have constituted disloyalty. Similarly, under the National Labor Relations Act, not all critical behaviors are sufficient for a breach of loyalty. For instance, a union newsletter that discussed broad political issues such as right-to-work laws and the minimum wage also had in it some specific complaints about the employer, but the court found, or the board found, and the court approved, that this was protected speech because it had been in the context of larger political issues. And as we discussed earlier in the DirecTV case, some criticism of the employer's product by employees engaged in a labor dispute may be protected if it is commensurate with the employee's grievance against the employer and is not maliciously untrue. So does the answer to any of these questions differ based on what the business of the employer is? I would have thought no, but the answer actually is maybe yes. Certain industries have a greater scope to discipline employees for the content of their speech than other employers do. For example, newspapers get special consideration in terminating employees for political speech. The McClatchy case that is listed on the slide is an example of that. In that case, the Washington Supreme Court upheld the transfer of a reporter for her public political activities. She was demonstrating on issues related to gay rights as well as abortion. Both of those were in conflict with the editorial policy of the newspaper at the time. So she was not terminated, but she was moved from her reporter role. And the court upheld that transfer as not a violation. But the LA Focus case indicates that right by newspapers to take action only goes so far. The court there held that there is not an unfettered right for newspapers to terminate an employee for any outside the newspaper speech, but acknowledged that there is some limited right, and it may well exist for newspapers protecting their editorial content or viewpoint. Interestingly, the New York Times has recently announced a stricter social media policy for its employees. Curious to see how that all plays out, but my guess is that any litigation resulting from the enforcement of those policies will certainly get significant press attention. There are other industries where the nature of the profession may be legally relevant. One of those includes the arts. There's a case involving the Wayans brothers that involved a claim of harassment, but because the harassment allegedly occurred in the context of filming a movie and on the movie set, the court found that that was relevant and dismissed the employee's harassment claim. Another group that has leeway in taking actions against employees for what might otherwise be protected speech are unions, interestingly enough. They have a federal statutory right to fire employees who openly disagree with their political activities. So as you can see, there are certainly many changing things that are going on in this area of the law, and we're going to keep you up to date on the changes through our various publications. And I'm going to turn back to the operator for just a moment to let you know what you need to do to submit your questions.
Thank you. Our speakers will now take your questions. As a reminder, to submit a question, go to the chat pod located in the lower left-hand corner of your screen. Type your question in the available box and click on the Send and Submit button. And we're getting the correct handout in the Handouts tab now, so give us just a minute and then you'll be able to go download that. Okay, Pat and Matt, I'm going to hand it back over to you to handle the questions.
All right, Matt, I'm going to let you take one of the first questions that we have received. The question is, and I'll read that and let you take it on, that there's some confusion about whether saying employers cannot terminate employees who make racist comments in the workplace, that is, if those comments are not related to strike activity. So Matt, take it away.
Right, so this must come out of my discussion of the Cooper Tire case, so my apologies for any lack of clarity there. The racist comments in that case were made in the context of a labor dispute. In other words, there was a strike going on, and the employee was attempting to intimidate or insult one of the replacement workers who was crossing the picket line. So the finding was by the NLRB that was upheld by the circuit court was that these comments were made in the context of a labor dispute and therefore constituted protected activity. So the issue was not that all comments, racist comments in the work, are protected under the NLRA, but rather that even racial invective that is not necessary to the expression of an opinion about a labor dispute can wind up being protected, given the context of an ongoing labor dispute. And again, there's other examples of offensive conduct, disparagement of an employer, which under ordinary circumstances would not constitute liable, an employer would not be liable for acting to discipline them, that in the context of a labor dispute become protected activity. So that's just something to be careful about if you're dealing with organizing on the part of employees.
Thanks, Matt. So another question that certainly arises regularly is whether an employer can prohibit all political speech in the workplace, regardless of what it is that the employees want to discuss. And I think the answer to that is likely if you have a policy that says there is no solicitation, that and arguably political speech fits into that definition, you are hard-pressed to prohibit speech during times that employees are not in working areas and not in working spaces. However, that's different from supporting the speech. That is, the fact that employees can engage in conversation on political issues on their own time and in their own space is not the same as allowing them to solicit others to join them. And if the employer wants to prohibit all such solicitation, it is our view that as long as that policy is clear and enforced uniformly, the employer likely can do so. Matt, how about if you take the next question, which is whether an employer has an obligation to agree to a request from certain employees that they be allowed to work elsewhere because of strong political or social or religious beliefs of a coworker with whom they currently work in close proximity.
Yeah, so this is an issue that I think doesn't have a categorical answer. There's certainly no obligation to accommodate a request to be distant from another employee unless somehow that could be tied to, say, a disability such as an allergy or something like that. But the basis of the relocation being political beliefs, there's no requirement that the employees accommodate those kind of requests. I will add a caveat, though, that if the behavior on the part of the employee who, the other employee is requesting distance from, escalates to the point of harassment or other actionable behavior, an employer could be held liable for failing to act or for permitting a hostile work environment to move forward. So it's worth investigating the source of the employee's request, but under these state laws and under most legal schemes, there's no requirement to accommodate this kind of relocation.
Thanks, Matt. So that really leads right into a follow-up question that has come in from your earlier answer, and that question is, so we've got an employee who's making racist comments. They're unrelated to strike activities. Question is, can that employee be disciplined even if the comments seem politically motivated? So not related to picketing or strike activities, but perhaps politically motivated. Matt, do you think that employee can be disciplined for the racist comment?
Well, this is where, under some of these state statutes, the answer becomes very fine. The differences between a permissible action and an impermissible action can be really hard to discern. So, returning to the fact patterns we discussed earlier under the California law, where an employee tore down the gay rights poster, the court found that it was actually a factual issue what the employer's motivation was, and that the employee had at least presented prima facie evidence that the employer didn't act to discipline the employee right away for the policy violation, but waited for the employee to announce the employee's political beliefs and used that as the basis for the termination. So under these California statutes, there is a risk that if you terminate an employee for racist comments outside of the context of a labor dispute, which would raise NLRA concerns, you might be seen as terminating the employee for their political beliefs. However, if you have a clear policy on a work environment that doesn't permit, say, racial comments or other kinds of harassment, and you make a case that the employee violated that policy and have a clear paper trail that you are terminating the employee for that violation of policy, I think you're on firmer ground and could potentially defend against these kinds of claims.
Thanks, Matt. So another question that has been submitted is whether or not an employer can control an employee's negative comments about a customer. And the answer there is a firm maybe. If the reason the employee is making the comments about a customer is otherwise protected activity. So if, for example, the employee is complaining that the customer is engaging in discriminatory activity, bullying or harassing the employee in a way that would be unlawful, or if the employee is complaining about the customer in the context of otherwise protected activity, an organizing campaign, for example, or collective bargaining negotiations, it gets very difficult to draw that line. Certainly, it seems easy to say employees can't go around bad-mouthing customers because that's bad for business, but you have to dig deeper and find out what the full context is in which the employee's comments were made before the employer would discipline the employee for making negative comments about a customer. All right, I have one other question that I'm aware of, and that question is whether an employer can allow employees to promote certain charitable activities while excluding political promotion. And it's somewhat related to the question that we dealt with before. But I think the answer there is, again, probably yes. If the question is, are we going to prohibit all solicitation for political candidates or political causes on our premises as the employer? That is probably a defensible position so long as it doesn't interfere with union organizing. That it can never interfere with that if that union organizing solicitation is taking place not on working time and is otherwise lawful. So having a policy that says we're going to allow certain charitable solicitations, as long as the policy is clear and is uniformly enforced in that sense, carving out a certain sort of activity is not necessarily going to result in liability to the employer. Again, have to be very careful in doing it, but if the employer's decision is all political activity in the workplace has, in your experience, been construed to be divisive, I think you could draft a policy that would permit you to say, we're not going to allow that here because it's not consistent with our culture within the company. Doesn't mean it wouldn't get challenged, of course, but I think there are ways in which such a decision could be made and could occur. All right. So I believe that exhausts our questions, which I think means I'm turning this back over to our operator.
Thank you. That completes our presentation for today. For CLE credit, let me find the evaluation here. And I don't see the evaluation loaded either. Sorry for all the technical difficulties today. We do have the presentation loaded, though. So we're going to have to send you an email with the evaluation link in it, I guess. And you'll need to complete that for the certificate of attendance. Please allow 4 weeks after the program to receive it. Well, thank you for your participation. We look forward to having you back for other programs in the future. Have a wonderful day.